Millions following the law, still at risk. You live in a state where you follow every rule. You bought your magazines when the law said it was okay. You stored them safely, you trained, you complied. Now, the law turns around and says that the same magazine could land you in jail. That's the fear millions of Americans are living with right now. Not because they've broken the law, but because the courts can't seem to decide what the law even is. And the one case that could settle it all, Duncan vs. Bonta, just got pulled back into limbo by the Supreme Court. Today, we're breaking down what this sudden move means, what's likely coming next, and why this fight over accessory laws like magazine bans might decide the future of the Second Amendment itself. Today, we're breaking it all down. But before we get started, please subscribe to our channel and hit the like button so you do not miss any updates. What just happened to Duncan v. Bonta? You might have heard that the Supreme Court had finally scheduled a conference for Duncan vs. Bonta. That means they were supposed to meet, review the case, and decide whether to officially hear it. After months of waiting, gun owners across the country were watching November 21st like a countdown clock. Then, without warning, the conference date vanished. Literally disappeared from the docket. And what replaced it? Just one word: rescheduled. No new date, no explanation, just gone. Now, the case that could have knocked down every magazine ban from California to New Jersey is back in legal limbo. Here's why this matters. Duncan vs. Bonta isn't just a California issue. It challenges the idea that states can ban commonly owned items, in this case, magazines holding more than 10 rounds, even if those items are legal under federal law. The Supreme Court's silence signals uncertainty. Are they waiting to combine it with another case? Are they unsure how to handle it politically? Or are they trying to dodge the question altogether? This same rescheduled limbo happened before. With the Snope vs. Garland and Ocean State Tactical v. Rhode Island cases, the court delayed its conferences and eventually denied both. That's what has everyone on edge. Because unlike other 2A fights that deal with full firearms, this case is about accessories, and some argue that's a lower priority. But if your property becomes a crime just because of a new law, that's not a technicality. That's a constitutional crisis. The backstory: Duncan's twisted timeline. Let's step back for a moment. The Duncan case has been dragging on for nearly 7 years. It's bounced between rulings, appeals, injunctions, and back again. In 2017, California passed a law banning possession of magazines over 10 rounds, not just future sales. That meant millions of legal owners were suddenly criminals unless they surrendered, sold, or destroyed their property. A lawsuit was filed. Duncan vs. Bonta. In 2019, a federal judge ruled in favor of gun owners, striking down the ban. California appealed. The Ninth Circuit reversed that win. Then came Bruen, the 2022 Supreme Court ruling that changed how all 2A cases must be judged. That gave Duncan new life because, under Bruen, the burden shifted to the state to prove its law fits American history and tradition. The Ninth Circuit, now under Bruen's rule, heard Duncan again and still upheld the ban. So the plaintiffs appealed again, this time to the Supreme Court. And that brings us to where we are now, watching the docket, waiting for a decision that keeps getting delayed. Why this case matters beyond California. Some people, especially those in gun-friendly states, argue that the Supreme Court should wait for a better case, maybe one involving AR-15 bans or handgun restrictions. But that thinking ignores a key truth. Rights don't depend on location. If your state doesn't ban magazines today, great, but the moment the court signals it won't intervene on accessories, it gives a green light to other states to follow suit. And they will. Let's be clear, the stakes are massive. Over 20 states currently have magazine restrictions or pending legislation to introduce them. Some states have criminal penalties for mere possession, not just use. Law-abiding citizens could face felony charges for having a magazine they bought years ago during a lawful window that suddenly becomes illegal again. That's not the law. That's retroactive punishment. Real people get caught in this. In 2020, a man in New Jersey was pulled over for a routine stop. During the search, police found a Glock with a 15-round magazine. He had bought it before the state passed its 10-round law. He was a security guard. No criminal history. Still, he faced felony weapons charges, not because he committed a violent act, but because his magazine was too large. That's not public safety, that's legal entrapment. Hope turns into uncertainty again. There's a reason people have been so emotionally invested in this case. For Californians who have lived for years under some of the strictest magazine laws in the country, Duncan v. Bonta felt like the one shot at rolling back what they saw as unconstitutional overreach. And when Judge Roger Benitez struck down the ban as violating the Second Amendment, it sparked hope far beyond California's borders. It gave a glimpse into what a post-Bruen interpretation of the Constitution might look like. But even that victory was short-lived. Ninth Circuit reversal clashes with Bruen. The Ninth Circuit overruled Benitez and reinstated the ban, justifying it on the grounds of public safety. In their view, high-capacity magazines weren't protected because they weren't historically necessary and posed a modern threat. But that analysis directly clashed with the Supreme Court's Bruen Standard 1, which required gun restrictions to be consistent with the historical tradition of firearm regulation. That's what sent Duncan back to SCOTUS, a clear conflict in judicial interpretation, a test of whether the highest court would reinforce or retreat from its own precedent. The reschedule heard around the country, and now, instead of certainty, we're back in limbo. There's also a deeper problem here, one that's not just legal but psychological. When the Supreme Court reschedules a conference without explanation, when it lets a case like this hang in the air without any clear timeline, it sends a message, not to the judges below but to the American people. It says, wait, hope, but don't expect clarity. For millions of lawful gun owners, that uncertainty can feel like punishment in itself. States are taking advantage of the silence. There's a parallel here with what happened in New York State Rifle and Pistol Association versus Bruen. In that case, too, hung in the background of national conversations for months. When the ruling finally came, it changed everything about how courts evaluate Second Amendment restrictions. But getting there required patience, and during that wait, many states tried to rush new laws into place, hoping they'd slide in under the wire. And that's what we might be seeing now. In the absence of a clear SCOTUS ruling, states are playing offense. Colorado, Oregon, and New Jersey, all with laws restricting magazine capacity that mirror or even exceed California's in scope. Some are using the delay to argue that their bans are still legally viable. Others are just waiting, knowing that each day without a ruling is one more day their law remains in effect. Real people are getting caught in the middle. And for the gun owners caught in the middle, they're left trying to follow laws that may be overturned tomorrow or enforced with felony charges today. Let's not forget the human cost behind all this legal theory. One wrong turn, one traffic stop with an unloaded 17-round mag in the glove box, and suddenly you're fighting for your freedom. Not because you committed violence, not because you hurt anyone, but because your state considers the tool you legally bought to be contraband. That's what this case is about. Whether the Constitution protects the right to own standard capacity magazines, or whether that right can be regulated out of existence with the stroke of a pen. We've seen the court act before. We've seen this before. In Cayetano versus Massachusetts, the Supreme Court reversed a conviction for stun gun possession, stating that just because a weapon is modern doesn't mean it isn't protected. That same logic applies here. So why the delay? Why reschedule a case that's been waiting for months? Legal analysts have floated a few theories. The court may be waiting to pair Duncan with another case like Gazzola versus Hochul or Gators v. Garland. It could be a procedural issue such as a missing brief or a pending related case. Or it may reflect internal disagreement among the justices, with some hesitant to take on a case so politically charged. But none of those explanations offer much comfort, because while the justices debate doctrine, the rest of us live under the consequences. Here's what you can do right now. You might be wondering what you should do in the meantime. If you live in a state with a magazine ban, how do you navigate this legally and practically? First, know your state law. That sounds obvious, but in places like California and New Jersey, the rules change often and aren't always clear. Sometimes bans are active, sometimes they're blocked by injunctions, sometimes there are carve-outs for law enforcement or pre-ban ownership. Second, consult a local attorney who specializes in firearms law, not your cousin who practices divorce law. A real expert who knows how state and federal courts are interpreting Second Amendment challenges. It's not just about knowing your rights, it's about knowing how to protect them under pressure. Third, document everything. If you purchased magazines legally during a window of legality, like the week after Judge Benitez's initial ruling, keep those receipts, take screenshots, note serial numbers. Because if enforcement returns, that paper trail may be the only thing standing between you and a criminal charge. Don't let delay turn into defeat. And finally, keep perspective. Yes, it's frustrating to watch the legal system stall. Yes, it feels unfair when courts delay decisions that affect millions of lives. But this isn't the end of the road. SCOTUS can still take the case. The justices can still make their voices heard. And when they do, It could trigger a domino effect across the country. If Duncan is granted review and the ban is overturned, it would force lower courts to finally align with Bruen. It would end the judicial resistance that slowed down Second Amendment victories since 2022. And it would restore some clarity to a space that's been muddied by politics and patchwork enforcement. This is not the end. Stay alert, stay prepared. So yes, the Supreme Court just backtracked. But that doesn't mean the fight is lost. This is a pause, not a surrender. Keep watching the docket, keep challenging bad laws, and most importantly, keep understanding the system that governs your rights. Because it's not just about gun owners, it's about the Constitution. And if you believe in that, it's worth staying in the fight. Know the rules, stay calm, and protect yourself the right way. And if you found this breakdown helpful, make sure you subscribe. We'll be here to explain what happens next, no matter how long the courts keep us waiting.